My lord, so for saying it is good I say it. We are grateful, my lord. Well, Mr. Can you tell this court your name?
My name is Adeomi Samuel.
Can you speak up, please?
My name is Adeomi Samuel Olori.
Olori, how do you spell your Olori?
Zero Olori.
Olu. Quickly, the guarantor's letter, who signed it with you?
Sign it with me.
Yes.
Nobody signed it with me.
Speak to the
I
court.
said nobody signed it with me.
Nobody signed it with you.
You said who signed it with me?
Said nobody signed it with him.
Huh?
You know your voice is should be and your voice is you speak rapidly. So please, knowing that I put down everything that you said, you will try to speak into the microphone and then take it easy.
Thank you.
Is there nobody signed it with him? Mr. Olori, are you aware that the second defendant there, who is the second defendant there? Let me ask. Who is the second defendant?
Is as at then Mr. Dr. Abati.
Is Dr. Abati.
And now, which I'm just hearing that you said is a proof.
Okay. Mr. Olori said he only knows Dr. Abati.
Abata, yes.
Mr. Abati is a witness. He's an adult. He can talk. I know the line of my argument. He only knows Mr. Abati.
Abata, sir.
How do you get to know Mr. or Professor Abata?
Yes, I worked in the academic staff establishment at that time, and he was a staff of the university, and he stood.
He was or is still a staff?
He was a staff of the university at that time, and he stood as a guarantor to.
He is a staff now or before? Has he resigned? Has he been sacked?
I don't know his current status now, sir.
Now, that's your answer.
Okay.
He just said he works with the university, that he knows him, he works with the university. And I now ask, is he still working with the university?
I said I know him, he works with the university at that time. I don't know if he's still there. And I also said that he stood. I also said,
hold on there.
Sir, please.
Answer my question. Answer my question. And stand right. That's not how to stand in the court, please.
Thank you, ma'am.
Are you aware that now Professor Matthew Abata is the HOD to the first defendant? Are you aware now?
Except now that you are saying it.
Did you hear the first defendant say it?
But I heard when he was saying it.
Thank you. Are you aware that a naked agreement without a definite consideration does not beget obligation? Are you aware of that?
In this case,
it doesn't need to be. Let him answer. Now, whether he knows or he doesn't know, let him leave principle of law. Somebody that says he's a witness, he has read through the file, knows the file. Has he complained?
Huh? I don't.
I heard. Don't know. Say I don't know.
But, my lord, the agreement, the bond we are talking about, at the time they were entering into the bond, it's something that the university cannot say this is the amount that will be involved. So the content of the bond already speaks for itself. I said, ma, that yes, ma. As at the time they were entering into this bond with the university, it's a 4-year period, so the university cannot at that moment calculate how much it will take. It is after the bond has been exhausted and the person defaults that the university will be able to calculate how much they've paid or how much it has cost the university for that person's training. So the content of the bond already speaks for itself.
So you are sure now that that bond beget nothing, because as at that time there was no certainty.
It's because something, sir, because all the
Was there
parties,
certainty? You just told the court that it is after that you do your calculation.
sir, when you enter into
See, you
the
said
fact
now,
of the bond,
you
sir,
said now that it is after you do your calculation.
sir, the
Is
fact
that is what you just said.
I said when a university commits itself to a staff training, the person takes 1 year initial instance and the person can decide to exhaust the 4 years. And after the 4 years, the person is supposed to serve the university. If the person defaults, the university will calculate how much the person has collected.
That is what it was not even in contemplation before. They will start to calculate
By the content of the bond, it is part of the contemplation, sir.
At least you have just told the court that it is after they do the calculation.
And I said by the content of the bond, it is
Are you
part of
aware
the
that the
contemplation, sir.
second defendant was never served with any correspondent from your office, from your school, as regards this agreement, I mean what you are calling the bond training or this? Are you aware that the second defendant was never carried along, was never served with any process? Are you aware of that?
Sir, it's not the university's.
Aware of that?
He entered into the bond.
Aware.
And the bond is a correspondence, sir. So I'm aware that
You are not what?
The bond is a correspondent and a contract.
I say any, you have never been served with any. Are you aware of that?
Sir, he signed the bond.
Oh my God. Are you aware that he has never been served? Served. I didn't say signed, served.
Is it after he
How old are you,
defaulted?
sir? How old are you? How old are you?
I'm 42.
You are 42.
Yes, sir.
What is your educational qualification, sir?
I'm currently undergoing my PhD, sir.
Thank you so much. So it's a very clear question.
I understand the question. I'm trying to answer the question.
Answer my question straight. You are talking to the court. We are not here to play semantics. We are doing serious business here. Are you aware that the second defendant was never served with any correspondence between the claimant and the first defendant? Are you aware of that?
Please come again.
Are you aware?
At what point are you talking about?
Let me put it this way. You said there is a bond between the first defendant and your school.
Yes, and he stood as guarantor.
There is a bond between the first defendant and your school.
And because he stood as a guarantor, he's part of the bond.
Let me ask you a question. Don't jump. You see, I have plenty of questions, 43 questions.
That's fine, sir.
So don't jump. We'll go there. We'll get there. Even if it's next year, we'll get there.
That's fine.
So you have time to talk. Are you aware that the second defendant was never served with the correspondence between the claimant, who is your school, and that of the first defendant? Are you aware that he has never been served with any?
If by what you mean is...
Can you define who is a guarantor? If you are running on... Who is
a guarantor is somebody that stands for somebody that in the event of default...
On his 2 legs or
sir,
1 leg?
In the event...
When he's standing. Tell me the meaning of standing.
Let's
go there, please. Answer my question direct.
I think, my lord, sir, I think this is unfair.
Mr. He should answer my question. He should answer my question.
It's asking, you are badging. It's not fair.
He badged at me. When he was badging, did you correct him?
It didn't go in cross-examination.
When he was doing it, you didn't. I was looking at you. I was deliberately looking at. I thought you would caution him. I'm so sorry, my lord. I was watching him when he was badging. I looked at him. My colleague looked away, was laughing. Mr. Agbaji, When we leave here, we'll still go and eat our amala. But let us deal with ourselves here. We know where to amala. We meet at amala joint. My lord, this is what I saw. So I will see. You will still buy me amala whether I like it or not today. So we should leave that area. Yes, my lord. As the call pleases.
I'm hoping that I've always hoped that you will assist before.
Yes, sir. That's what I'm doing, sir. That's what I'm doing.
When you ask this question, and this man starts to answer, once he goes for any direction you do not like.
I love all the direction.
Try to stop him from going that side.
My lord, just to the time of the court is what I'm doing. The time of the court. You should just answer my question straight. The rhetorics, you should leave the rhetorics for address. You can give the lawyer this for address. As a couple, please.
And he gives his answer.
As a couple, please.
If you do not, if that answer doesn't really then you don't have to maybe rephrase.
As a couple, please. As a couple, please. What my
because this thing can say I'm only hearing you through my system here, and it is echoing. When he's talking and you're talking, there's just
as a couple, we did apologize for that. We did apologize for that.
What's that? Let him answer.
As a couple. So the question still remains: did you serve the second defendant with any of the correspondence that have been going between yourself and the first defendant? Did you serve him with any?
Yes, by virtue of the bond, sir.
Can you mention the one that you have served him with?
The bond, he signed the bond as a guarantor.
One.
And that's how far I can recall, sir.
Are you aware that the first defendant has been dismissed by your school, by your institution? Are you aware?
I'm aware, sir.
So why didn't you mention that? You are concealing facts.
You never asked that.
I say how many are those corresponding that goes between yourself?
Okay, you mean the second defendant? Recall I said when I said it was then the HOD, you said it was in the university as I was in the university. I said I can't really see, but at that moment he was a staff of the university. So that's what I said earlier. So when you said second defendant, I was thinking it was Mr. Dr. Samsudin.
First defendant is Samsudin. I explained everything to you before we started. That's why I said Samsudin should lay foundation.
Yes, I'm maintaining,
so
sir.
we understand it.
Sir, I'm maintaining my earlier statement when I said that as at that time when it happened, he was a staff of the university.
For information of Professor Macha, he's still a staff.
Well, like I said earlier.
If you don't know, you are aware now.
No, you just said it now, so I'll have to check our records, sir.
You are aware that this is staff.
Well,
are you aware now?
I'll confirm that, sir.
What are the qualifications of your so-called guarantors? Before you take somebody as a guarantor, what are their qualifications?
Well, the procedure is that when somebody enters into a bond with a university, the person has to bring somebody, and the person must have a valid identification card.
Like what kind of card?
When I say valid, it could be international passport, it could be your passport, it could be your staff ID, it could be voter's card, it could be something valid that is recognized by law in Nigeria.
So which of these documents from the second defendant that you have?
Well,
that you have mentioned now.
Well, at this moment, I can't recall. But I know that at that time it was a staff.
You said, I said qualification. I'm not saying, what are the qualifications that you said you demanded from your guarantors? You said ID cards and the rest.
Yeah, those are means of identification.
Which of these ones that maybe you just took photograph of it and collected from him? Maybe.
Well, the person at that time was a staff of the university, so that may suffice.
So you mean he's a staff? That's what you are saying? Because you just told you that you don't even know if it's a staff.
I said as at that time.
So, but are you aware that there's no correspondence that goes between the second defendant, I mean your school, and the first one that the second defendant is aware of?
You mean after the first defendant's dismissal?
Even from ab initio.
If you talk about correspondence, he entered into a bond. So
That's why I said, are you aware that none was served on him?
that he entered into a bond, that's the correspondence. It was
Are
served.
you aware that none was served on him? Are you aware?
He was served. If he was served.
Okay, he was served.
Yes.
Are you in court with a copy of what you gave to him that he acknowledged? Are you in court with?
Sir.
What you served him with?
Sir, if we look at the content of the bond, his name, signature, at least will be there.
I said, is a question, are you in court with what you claim you said?
The bond.
What he acknowledged from
okay,
you, from
sir,
your university?
Sir, the bond would have been tendered in exhibit.
I said, are you aware and that none that he acknowledged? If you have it, can we have it in court? The one he acknowledged.
Sir, when you look at a bond, somebody signs a bond, the person who signed cannot claim ignorance of what he or she signed.
Are you also aware that the bond agreement you are even talking about is prepared in anticipation of a case like this?
That's not
it was
true,
made mala fide.
That's not true, sir.
Bad faith.
That's not true, sir.
But are you aware?
That's not true, sir.
What is the role of heads of departments in your institution? What are their roles? Heads of department in any bond agreement entered into by your institution and any of your staff.
Thank you,
What is the
sir.
role of the head of department?
A head of department has no special role in a bond. A bond agreement is an agreement between two parties, the university and the person entering into the bond. So there is no special role for the head of department.
As a couple. You said there's no nexus.
I said the bond is between two parties, university and a staff who entered into the agreement. The staff can bring any person. It can either be a colleague, head of department, the VC, anybody can enter into, stand as surety or guarantor for that person. So the head of department does not have any special role.
Just between those two.
And
so
they are surety, sir.
Are you aware that this bond is intended to spite the second defendant?
Sir, if you look at the content,
are you aware?
The university enters into bond without, we don't enter into bond with any bad faith. That's not true, sir.
Does the university have any staff book?
Sir,
we have any staff book?
We have a condition of service.
The handbook.
We have a condition of service, sir.
Do they have it?
We have condition of service, and
Are you in court with such?
At the moment, I don't have one, but with university has it. Every staff has a copy of the condition of service, and it's even in such copy, so it is available.
Oh, good. My Lord, in our statement, we had asked in our paragraph 4, we had asked that the handbook, the senior staff handbook, we put them to give them notice to produce, and I believe is in court today. Probably we can have one of the, as they must have tendered it in evidence. Maybe we should give him to read. As a cop, because I wanted him to read some paragraphs of that, which I've mentioned there in our statement of defense. My Lord, why we still leave that question? I can still ask other questions so that when we take, yes, sir. As a cop, please. In your claim, you said there was a meeting held on the 7th day of September 2017. Are you in that meeting?
7th day of September
Yes.
2017.
Yes. Are you in that meeting?
Do you imply the council meeting or the
Are you in
AMP?
that? You are the one that wrote it. I can't imply for you now. You signed it. That's me.
So I just want to be sure. I can't recall the exact meeting you're talking about.
My Lord, he can't even recall.
I know there are meetings in
He knows that
September.
he signed.
My Lord, we have an AMP meeting. The university runs a committee system. We have the appointment and promotions committee meeting in September. We also have another council meeting. So
You just
it's
said
a
that
process.
anybody that signed document knows that he's the one that signed. You are the one that signed this oath. Or you want to tell us you are lying on oath?
I'm talking about the exact date you quoted. You said
I said
7th.
It's a 7th day of September 2017.
Well, if that's the AMP, then that's the university organ.
Were you in that meeting?
I personally am not in that meeting, but I'm part of.
What are you doing in that box?
That, sir,
What are you doing in that
as
box?
a staff, sir, as a staff of the academic staff establishment, we all serve as secretariats for that meeting.
So you agree that there was a meeting on that day? I
said we have AMP meeting and we have council meeting, but I told you that the exact date you quoted is what you
didn't quote the
you said 7th September. So if it's
process, maybe you should check you're the one that deposed to affidavit.
I know I deposed to an affidavit.
So you see, you said there's a meeting on the 7th day of September 2017. My Lord, that's what they tender. That's what we are waiting for. Is an evidence before the court. I'm not in the possession of the evidence. And so I'm not in the possession of the evidence. If he claims he has deposed to an affidavit, he should know every line that he deposed. There's a presumption that he knows everything there. And Lord, if we can probably take a date, because so many things we have to call the document out, because we took 2 days, today and tomorrow again, sir. We are ready to come, sir. A letter that he wrote on the 7th day of September 2017. Yes, sir. I say, was he in that meeting? But he signed an under oath that there's a letter that they did a meeting. Was it? You should know we are all human beings. If I attend a party, okay, he said he's not in the party, he's in the meeting. Yeah, okay.
Yes, ma'am. Secretariat, ma'am.
So as a please.
Okay, my lord.
So since he said he knows about the letter and he was at the meeting, I cannot further ask my question. Since you are in the meeting,
I said I'm there as secretariat.
Since you are in the meeting, whether secretariat or machine, since you are in the meeting, and as a secretariat in that meeting, do you have the minute of the meeting?
That's where I'm going, sir. As a secretariat, we don't put names on the attendance. We only assist the secretary of the meeting in writing minutes and all those things.
Okay. I'm not talking about your personal self now. You are representing an institution. I don't even know you. I know the claimant. But the claimant has pushed you forward that you are there. That's why you are receiving these questions. Ordinarily, I don't have business with you. So, number one, where is the minute of that meeting of that 7th September 2017? Are you in court with that?
At the moment, I don't have it with me.
They are not in court with the minute of the meeting of 7th. Yes. Was the defendant part of that meeting that day? Second defendant, Professor Matthew Abata, was he in that meeting?
I don't think he was part in the meeting.
The second defendant was not part of the meeting. If you claim that he is the guarantor as you have been chanting since, is he not supposed to be part of that meeting?
Thank you, sir. Meetings like that, we treat
Is he not supposed to be part of
at that moment, he cannot be,
now.
sir, at that moment, he cannot be part of that meeting because the meeting was to consider. Can I go on?
My lord, he said the second defendant was not in the meeting.
You asked a question. Can I go on, sir?
It's okay.
My lord, can I go on?
It's okay. I've asked my question.
At that meeting, it was to consider the fact of the matter of that is the abandonment of duty and amongst all that. So it is after he has been dismissed, the first defendant has been dismissed, and that is when the issue of refund the money that was paid to you. If not, your guarantor will have to be liable for it.
So was there any letter written to the guarantor on the demeanor of the so-called first defendant?
Well, I can't recall, sir.
Because this one that you're saying. What did your institution ask you to come and tell this court this morning, this afternoon? What did your institution, your employers, what they asked you to come and tell this court this day?
Well, I'm here in respect of the witness oath I
What did they
disposed
ask
to.
you to come and tell this court?
Tell this court, what do you mean by that, sir?
I mean, what they send you to come and do in this court?
This morning.
This afternoon.
This afternoon. I don't understand the question you are talking about.
My lord, is a question. My lord, if we are going to Third Mainland Bridge, we'll still pass Osborne. We are around Osborne now. We just want to take a bend. What did your employer ask you to come and do in court today?
Okay, I'm here as a witness in the matter.
Witness to who?
In the matter between the university and the first and second defendants.
My lord, the register is here. Don't know if we can record this. Okay. If you cannot get it today, we still have tomorrow. So we are not afraid. In the paragraphs of your affidavits, you actually mentioned that the first defendant was only to serve the claimant for at least 5 years. Are you aware of that?
Yes, sir.
Good. But we are surprised that before the 5th year, you only approved 4 years. In your statement, you only
Thank you, sir.
approved 4 years.
Thank you, sir. The policy in terms of bond says that you can go for 1 year and come back, 2 years and come back, but the maximum period you can spend is 5 years.
You say, no, maximum, say at least. That's what your statement. Say at least. Is it enough?
No, I said the maximum period you can spend for any bond is 5 years when you return.
But you said at least. What is at least? What is maximum? They are two different things. Are you talking tongue in cheek now?
No, I'm not talking.
He said at least. It's a written document. At least 5 years. And all of a sudden, what you only approve is 4 years. We are going somewhere, sir. Are you still aware that even this second defendant is not even aware of all these your discrepancies and all what you have been doing underground? Are you still aware?
There was never a discrepancy, so I'm not aware if there is. We never do any.
But are you aware that he's not even aware whether discrepancy or not? He's not even aware.
Aware of what, sir?
Aware of what you have been writing or what you have been sending. It is only in this court that we got to know that you have been doing all this from what they serve me with. Are you aware that he's not even aware?
Well, he's a guarantor, so the contract is.
He's a guarantor in the air.
The first defendant ordinarily should at least carry his guarantor along wherever he's doing now.
I'm saying guarantor. Why is he not even invited for the meeting as a guarantor? It's a guarantor. Why is he not invited? Why is he not invited?
You don't have to necessarily be in that meeting.
So it's not necessary to be a guarantor there.
If you are in, sir, if you are a guarantor, definitely there is the issue of trust and good faith.
You say you are a doctor in view. In common law, if you are carrying a benefit, you must be ready to carry liability too. If you are hinging on liability and you decide to relegate him to the background when the issue of benefit comes, that means it's not a fair thing.
So
I
think it is the responsibility of the first defendant. The first defendant should have carried his guarantor or surety along wherever he's doing.
The first defendant said, yeah, he laid the fact that he doesn't even know. He doesn't have business coming to this court. So he said he's disappointed in last week.
Sir, if the first defendant,
sir, should even bring him.
Sir, if I am aware he said that, the question is this. It then means that he himself in the first instance, he bought somebody which he knew. He had the premonition that he would get to this stage.
That presently the first defendant has been dismissed by the institution.
At the court place, at the court. We are complete.
My Lord can maybe give us a line there. We'll see rephrase. My Lord can give us a line. What my Lord have?
Yes, that is the point. So I get online, another one has the fact when the area that I'm quite sure of is that when he was saying that you asked him that the bond was for 5 years or something.
Yes, sir.
But that, yes, he was telling us what is usually written there is that
My lord, what I said is that they said at least they're supposed to give him at least 5 years. Yes, sir. But instead of approving 5 years for him, they surreptitiously approve 4 against the run of play.
No, my lord, that's not what I said, though. That's not what I said, and that's not, sir.
You don't need to, you have deposed on affidavit.
Sir,
that's what I said.
If you have served the bond, you are supposed to, if you have been offered a bond, you are supposed to come back to the university and serve the university for at least 5 years. And bond period is only allowed for, you can go to bond for like 4 years. That you can, they cannot approve a bond for you for more than 5 years.
That's what I'm saying. Let me explain to you. You said, you have just said it that you have been given a bond. You are supposed to serve the university for at least 5 years. But you have
no.
That's after selling the bond or whatever the bond.
No, my lord, they said only at least 5 years.
My lord is right. My lord is right.
For at least 5 years.
Yeah. No.
Yes.
Maximum now.
So it's not as if
yes, sir. No, the point is not. We are saying if they have entered into that agreement, the first defender is supposed to come and serve the university for at least 5 years. But what did they approve for the first defender? Is it 5 years or 4 years? That's where I'm going, sir.
I said maximum period.
They approved 4 years.
My lord.
At least.
My lord, 5
I said years.
Maximum period of 5 years.
Yeah. Your statement is at least. That's the statement. It's there. It's there. Maybe you should. You said you must. You said they must serve 5 years. But they only approve 4 years. Where will you get the 5 years to serve? That's where I'm going. Everything is fraught with some delicate. If you say, my investing day, I only 5 years. And all of what I saw is 4 years. Where do I get that? As you know, the standing contract. So if
that's why I wanted to.
It's clear because they said you must come and serve 5 years at worst case scenario. But
after having done what?
After having entered into a bond.
A bond for how long?
For that at least 5 years. But what
they bond for 4 years, and after the bond, you come out and serve at least 5 years. That's what I think.
What me I'm saying
yes.
is that if they said you serve for at least 5 years, you should approve more than 5 years for him to come and serve. But you shorten the whole thing and ask you only approve 4 years. Is he going to come back and give himself? You cannot give what you don't have.
Okay. Since the bond is before the court, yes, so maybe in your final written address, you.
As a court, please, we are grateful, sir.
Yes.
Absolutely. Yes, are you aware that the first defendant was dismissed and acquitted by the Constitution? Are you aware?
I'm aware.
How do you get this loan back?
The defendant supposed to pay back the university having the
to come and serve.
No, sir. After initially with the university, no, he left. He abandoned the duty, and after he had been dismissed, then he's supposed to return the money that they spent on him, failing which the second defendant who stood as surety for him.
That's you said 5 years. That's where I'm going. If somebody, if you say at least 5 years, and you have 4, and all of a sudden you now vitiate the means of repayment. If you read the means of repayment, you didn't say go and pay other loan. You said you will pay through service.
Sir,
That is the point.
the first vengeance never resumed.
Collect my money back, coming to the boy. All of a sudden,
Sir, he never resumed duty. If he had resumed, sir, if he had resumed, we had the opportunity, but he never resumed back to the university. Rather, he absconded. He abandoned duty, rather.
he spoke with you directly.
In fact, sir, my lord, sir, can I add this?
Let me ask you,
My lord,
Yes.
calling the short.
Please, let's sort out this one.
As a public.
He said he never resumed.
yes, he
That
never
he abandoned what?
duty. In
Duty.
fact, he wrote to the university saying that the university should grant him another leave again after exhausting the statutory leave that had been granted. Sir, after he has, which one? Is it after he has exhausted his leave?
Yeah.
Because that is the contrary. That is contrary to the laws of the university. So the university did not grant it
That's that the university did not grant
because he has exhausted his normal, the statutory leave period, and he did not even return to the university.
You didn't grant.
He didn't return.
But said,
Sir, he did not return to the university. Yet, even without return to the university, he's working for another leave, and yet he has not exhausted the statutory period of the leave which is entitled to.
Did you drove him away?
We never do him away, sir. He knew the law, he knew the policy of the university, he's way abreast of it.
He said he did not respond. The claimant not respond to the first defendant.
My lord, may I add that he even appealed. Even after he has been.
That it is contrary to the rules of the university
Yes, my
to
lord.
grant a second, a further chance, second chance. When he did not resume as well.
Can you record the first and you did he signed? Can you record the date he signed out and who are the parties on the table when he signed?
Okay, sir. Let me put this into context. When you start the bond form, you are given the bond form to go and fill. And when you bring the bond form, you submit it after filling it. Your surety would have signed and all those things, submitted the necessary attachment to it. That is the procedure, sir.
Attached to the bond, as you have said now. Because I have it's still the same.
But I can't recall the moment.
What are those things that you said it was attached by this defendant to your guarantee?
Sir, when somebody fills a form, a guarantor form, a bond form, then we definitely check for if a staff check his ID. Then when you're having a shorty, definitely shorty will have a means of identification. Sir, when I click
back to where he said
it's the same question. So he has answered me. We are not going back. I've started what I
okay.
Technology. So they didn't even have anything that they attached or collected.
Yes. Well, I guess I didn't tell you that there's a limitation to the time for cross-examination.
I said you should take is either because what I wanted not here. That's why I've not asked questions, sir. So it's not my fault, sir. If the court can, he said they've gone. That's why I said, you know, I will take it. They'll come back tomorrow morning.
You didn't see it.
We can come back tomorrow morning, very early in the morning, as early as 9 o'clock. We do what we want to put in. We took 2 days, sir. 2 days.
Which other was that? I don't know if it's the same thing. I understand there's a handbook available, but I don't know if it is the.
We can take it tomorrow. We can. Tomorrow. Let me just ask these 2 questions so that we take a date, sir. So that and I'll continue.
And tomorrow your time will continue to read.
Huh?
And so when we come tomorrow, we'll take into consideration the time we have utilized today.
Yes, sir. That we will definitely. It won't take much time. I just want to ask a question in line of duties. That's all. So
I heard you say 2 questions.
yes.
2 questions, then finally and finally.
You also claim your evidence and on oath that there was computation and which reported a 11,424 or 11,424,000 naira 40 kobo. Is that correct?
Yes.
How do you go about that?
The budget department calculates all the monies that have
Is
been
the
paid.
budget department here to tell us about that?
Staff salaries were paid during those periods. We have our pay slip.
Are you the one that
Personally, not me, but it's the budget of the university that does it.
No, I didn't even hear any of his answers.
I said he also claimed
Yes.
Yes. Even on oath that the sum of 11,000 naira, 11,120,940 kobo is the attachment to the first defendant.
Is that standing what sum? Okay. Okay.
The question is, how have they now monetized service into 11 million? Because it at least served me for 5 years. How have they arrived at?
Thank you, sir. Can I answer that?
Yes.
Thank you, ma'am. The first defendant.
Thank you, my lord. Thank you.
The first defendant.
No, I don't. Okay.
The first defendant was granted training leave, and he for 4 years. First, it was the first instance and 3 renewals. That's 4 years. So those periods,
are you the one that computed?
Sir,
I'm supposed to be recording what you're saying. So you're just too fast.
So the mic. Are you the one that compute it?
Okay.
Are you the one that?
the bursary department of the university computes all the amount that has been paid to the person during the period he was away. The university has different departments. We in Esowe, we will write to the university to do the computation of how much has been paid to him when he was on training leave. And that is how we arrive at that amount.
So you are the one that said it.
Sir, you didn't get me, sir. I said we will request the bursary to give us the amount that has been paid to the person doing when he was on training leave, and that is how we will request the bursary to compute the amount that's been paid to the person while he was on training leave, not after. And all those people was paid to, definitely you can be on his pay slip during that period. So that is how we have that computation.
Did you tell him what he's entering into and how have you monetized it?
Thank you, sir.
Because it says serving 5 years. Now you are paying us another bread that is 11. How do you come about? This is very simple.
So I have explained.
I'm coming. And he said it is the bursary that computes it. I said, can we have the bursary? Tell us how they are.
Sir, my lord, I have explained. When look at the content of the bond, the first piece for itself. If you are served, it means that you have paid the university. Sir, my lord, the bond speaks for itself. If you were go to the bond, it shows that if you return and you serve the university, then you have served the university for what the university has spent on you, because that period of time you are supposed to also use that knowledge in the service of the university. But in this, if you fail, the bond says that you have to return whatever has been spent on you.
You tell him that you are spent so. Did you tell him supposed amount you intend spending on him?
Sir,
Did you tell him?
the bond fact already speaks for itself, sir.
Okay.
Did you tell that this is because the bond
Now he's fully aware.
no sum on him at all. There was no. And said to serve it out to 5 years. All of a sudden, we are seeing 11 million again. Only there that.
My lord, in the bond,
I can show you there was no monetary value.
my lord, in the bond, it says that if you fail to serve, then you have to return. It is clearly stated there.
But you know, you see, with this game, you don't give it and give that to the country. You are distracting us. Gonna you bring, you say it's from load all your costs. You are starting a different thing for what you tell that before.
My lord,
Process, you did not put anything. You said have 5 years. And you deceive the person like 5 years. All of this you are
my lord, I think there is this is not what I said.
Let me, excuse me. Let me say something. Let me know whether it's what you have been saying, because the witness has definitely refused to go slowly for me to know what to say. I don't know whether what he's saying is this, that if you, after 4 years of the bond, you come back and serve the university for 5 years, you're free.
Yes.
But if after the 4 years of the bond, you do not come back to serve the university, that it is at that stage that the university will now come and tell you, okay, within those 4 years, we spend this thing on you, we spend this and that on you. And that in this particular case at hand, that is how they arrived at the sum of 11 million naira, he said.
That's
yes.
But
yes, but that's what was that what he said?
That's not what he said.
That's what I said.
Only help.
That is what I said. My lord, I think the council is going to misrepresent what I'm saying. That you have just captured what I actually said.
Because I was trying to, get what you're saying.
My lord, Sergeant knows what he's doing. He's my friend, long friend. So he's not. My lord, what you are saying, if there's a certain contract,
Yes.
it should be spelled out expressly. Expressly other meaning. All the extraneous meaning does not add up,
my lord.
Look,
Okay, please continue.
Okay.
What I'm saying in essence is that if you claim and come back with this paper, and another break, you said I came back with money, which are we saying?
You should bring it up in your final written address.
As a cop, please.
Let us take it at the
As a cop,
start going halfway between rapid speech and loud one. There's a little bit of headache brewing somewhere in my head.
As a cop, please.
Yes.
As a cop. Lastly, for this day, did the first defendant actually embark on this study? If the answer is let us know is yes. If it's no, no.
Yes.
Yes, he did.
He went for study leave.
How have you been disbursing the 11 million to him? How have you been disbursing it?
He received his monthly salaries during those periods. And then salaries and emoluments are paid to his salary account.
So, you import how you are doing his account? Are you
Well, his pay slip will suffice.
You are the one that
yes, the pay slips are there. The pay slips are here, I believe. I think the pay slips are here, sir. Is
Let me question. Let me answer, Mr. Ngaji.
I said
when you put this exhibit, let us we will do it tomorrow. That's exhibit.
Well, in the absence of the exhibits, I guess this is a good time to stop. In the absence of the exhibits we are talking about, this is a good time to stop. So my people can go look for it.
So we need the exhibit to actually talk very well, sir.
So tomorrow we utilize the remaining 10 minutes of your.
My lord.
10 minutes or 5 minutes of your time.
It can't be 10 minutes, my lord, in the sense that I would have the talk about people. But if you avail me with the exhibit, it won't take me 20 minutes. I just need 20 minutes to finish what I'm doing. 20 minutes is okay.
I see.
20. My lord, I'm not done with talking. I'm not. Mr. Baji, you are a senior member of the bar. I am a good man, gentleman. It doesn't stop giving my malady this afternoon. So you are a good man. So don't be
this should be the end of it for today.
As a topic. We are going
tomorrow, yes. Of course.
My lord, may I come in at this point? My lord, this court is known for doing justice. And when we started, there was no specification that takes so point. In as much as we know that I have this now we don't have the evidence, we don't rely on to see what we want to talk about. If I should see it might not take me that, but let me see, I know what from what it's a very simple. So ask him to be short out a good thing from Mr. Baji. That's not it's not very no need to
no, he said that I've indulged you, that when it reaches his own turn.
Amount to intimidation is intimidating the court, that the court should note that should not give me that. My lord, It's a big threat. It's a big threat.
I know, Mr. Abacha, you cannot do a thing like that.
My lord. I know you very well.
So,
It's a subtle threat. And we will be watched by such.
okay.
My lord, we shall be asked, probably we come in the morning, Lord, so that we can tidy up what we want to do. We can't come. My lord, let's in the morning.
But I heard you say 9. It cannot be 9. It cannot be 9 a.m. like you said. It cannot be 9. Perhaps.
Because Professor, my lord, you know, the court is my lord, what I see, the mother will drive far to them. The mother will talk. The only thing the second office to be, and it is in contemplation. As I said, because in the old day is not effective. He comes all the way from
yes. Okay. So, but around yeah.
I we are not in testament, but even as it stands, we can tolerate and accommodate each other.
Okay. So at this stage,
my lord, we are still asking that 1 o'clock is not even feasible because by 4 o'clock, I should be in a meeting in Abuja. So it's not just opinion at all, sir.
Do we take another date then?
My lord, if my lord is willing, we will take and set up that.
I agree, Mr. Abacha.
Because
yes, if we can take another date, it will be better for me.
2:30 rather, tomorrow.
Yes.
Can we look at it in April, sir? Maybe guys diary for a date in April.
Please, quite.
Every day ideal. Just
That's it. Saturday of April. That's it. 30.
30th April.
Eh? How about 17th? Yes. Yes. How about you?
May I ask second if it will also be convenient for him to
go.
The second.
Yes.
The first 2 weeks.
Because of that,
first 2 weeks.
We must conduct the business of the court. We must conduct the business of the court.
Hello, the first 2 weeks ends on Monday 15. The first.
How about the 8th? How about the 8th of May?
My lord, we don't want to go too far, my lord. Let us. My Lord, this is bad. We are going to, my Lord.
Well,
This is bad. This is just early.
so
Today-
what do I do?
Today is
I
6.
think this one, somebody has a problem. Even now, somebody is saying he will not be there.
My Lord,
And it's not, it is not,
even we are supposed to even
not
immediately
proper that
after,
we-
we're supposed to open our
not
defense.
proper that we adjourn the matter at the instance of a witness. Mm-mm. Mm-mm.
So my Lord, you can come
So
back.
what happened about what happened tomorrow?
My Lord,
How about 11 tomorrow? I'd already written that at this stage, this matter remains adjourned till tomorrow. That is the 7th day of March 2024 by 11 a.m. for conclusion of the cross-examination of the second defendant. Okay. Thank you. And please ask, I don't know, whose witness is that? Olori, yes. That's your witness. Please let him know that he must really speak in a way that the court can record him. I don't have to say it, but if I don't record very, very rapidly, I won't even be hearing what he's saying. I told him, but because whatever he's saying was on record, and then work with it. Please. Okay. I guess you can go now and have your amala, as you said.